Kind of clears the table. So you're sitting there leaning forward, so you could hardly wait until they finish, so you could just jackrabbit on up here. So we're gonna see. All right, sir. Mr. Ternan, you're up.
Thank you, Your Honor. I do find this case very interesting, but it's a case that only lawyers would love. I represent the appellants, principally on this appeal. PetroTel Oman LLC is really the one where all the action is at. That is the entity that has the contract and relationship with the United States International.
I think we can hear you, but up it just a little bit, so make sure that the tape gets your voice good and clear, and so opposing counsel can get you.
Yes, Your Honor.
You can give us your theater, your thespian voice.
I will do my best.
All right, that works.
This case was filed in county court in Dallas County. It was removed to federal court under both 1441 and 1442. I'm going to focus most of my time on federal officer removal, but if you have questions and if I have enough time, I'll talk about 1441. This court has set forth four elements that have to be met to remove a case under federal officer removal. The defendant must assert a colorable federal defense. It is a person within the meaning of the statute that has acted pursuant to a federal officer's directions, and the charged conduct is connected or associated with an act pursuant to a federal officer's directions. I think the first two elements are largely undisputed. We've raised a defense that Mr. Box, who is not a licensed broker or dealer, who has said that he did all of these things. Well, if he had actually done those things, it would be illegal for him to do so, and any contract that he's claiming to have would be void. And we don't have to prove it at this stage, it just has to be colorable. I think it's also undisputed that the appellants are persons. So really the third and fourth elements are where the action is at. The district court didn't really say which of those elements she found to be problematic. She just said there wasn't a acting under in this scenario. And
it doesn't seem at all like these other cases. It's not a big electricity project. This is not anything for the government. The government doesn't require it to be done. So why isn't the district court just spot on in her analysis?
Well, the U.S. government does want U.S. companies to engage with the world, and there are certain projects like this one that do impact foreign policy. I mean, the oil...
It's not a service to the government. It's not something that has to be done for the government or for the people to function. It's not at all like that.
Well, there are many things...
It's not a Navy shipyard. It's none of the things that would be, this is a government operation and has to function. The fact that the government may spend some money and time saying you can do investment around the world and and we should have relationships with countries is not the same at all as a government project.
Well, I mean, the Congress has decided that it wants this entity to exist, the United States International Development Finance Corporation, and it says we are going to put the U.S. credit on the line, right? I mean, the government agency is guaranteed this project to investors. And the reason it has done that is it believes this project, which is on the Strait of Hormuz, is of importance to the United States. It didn't have to do that. I agree with you on that. But
the fact that it exists for people doesn't mean that it's a government, that it's for the government. It's not an electric plant. It's not a Navy thing that has to, it's not the kind of thing that is benefiting the government. It just is it's a program that helps people invest because they've determined in their wisdom that they want to support that.
Well, I mean, it helps the government in the sense that the taxpayers do realize a return from these projects. I mean, the oil and gas that's being developed and the proceeds from that sale then ends up, part of it, in the government's hands.
What is your best case that this type of more tangential situation is acting under?
There is no prior DFC or OPIC case, right? But the electric cooperatives is a great example, right? The government wanted electricity in rural areas. That's a sort of policy decision that the federal government made. Nobody could do it on their own, so they sort of encouraged cooperatives to be formed, and they set the rules for those cooperatives, and they set loan agreements for those cooperatives, and they sort of made it happen. And when you're in that sort of environment where the government wants something to happen, they can tell you how to do it, and the complaint about conduct is complaining about something the government sort of directed, you can remove to federal court. And that's, I think, the closest factual analysis to what's happening here. The federal government wants projects like these to happen. They decide which projects they want to go forward with. If they want to go forward with it, they tell you how to do it. They tell you who they want the participants to be. They tell you, what order events need to happen in. They tell you how much money to do it. And then they put the United States credit on the line. They go out to the private investment community and raise the money in their name, and then they give it to you. So the federal government is doing things, and they try to do it on the cheap by essentially having the party that's interested in getting the funds actually do all the work, right? So, in order for the DFC to raise the money, it needs a placement agent, someone to go out there and market these securities. But it doesn't want to go hire them, doesn't want to hire a headhunter, doesn't want to have that done in-house. So they say, you, PetroTel, go find me a placement agent, go interview these folks, give me their names, give me their contracts, tell them what to do if I decide to hire them. And yes, they can step in at any time and say, no, don't do it that way, do it this way. But they're essentially relying on the business that they are wanting to fund.
How do you distinguish Walker versus Louisiana? City of Walker versus Louisiana through Department of Transportation and Development. Fifth Circuit 2017 case 877 F 3rd 563. Perhaps I've sprung that on you.
Yeah,
I don't mean to be. I'm not. This is not a trick question. This is the case where it's a non-federal project, and they supervised and provide financial assistance in that case also.
Yeah, I'm not prepared to discuss
Okay, that's
that
perfectly fine. So you want to talk about Mitchell?
Mitchell is the one.
Private health care.
Private health care.
Maybe you don't. You talk about whatever you want to talk about, sir. This isn't trick time. I'm not trying to stump you.
There are a variety of cases where the federal government is funding something and there are sort of regulations that govern that funding, and this court has said repeatedly that that is not sufficient. And I think this is distinct in the way that we're not talking about regulations here, right? We're not talking about the laws. We're talking about a federal agency making a policy decision about what international projects does the federal government care about and want to see happen and want to have controlled and run by American companies, and sort of directing how that project will proceed. I think that is what makes it acting under a federal officer in a way that a lot of these other cases are not.
Did the DFC have any control or any supervision over the actual drilling, or just issue the COPs?
I mean, they don't have people on the ground in Oman, directing the drilling, right? But there are aspects of the contracts that sort of say how many you have to drill, those sort of things, right? So I wouldn't say that they had control over the drilling. But this case isn't about the actual drilling in Oman, right? It's about Mr. Box claiming that he was involved in essentially helping us get money out of the federal government. And he should be paid a fee for doing that. So the issues in this case are the issues that the federal government was involved in and are the issues that were acting under their control.
But you seem to be arguing just any kind of a tangential or, just being able to show somehow the government is within sight, so to speak, is enough to, carry the day. So although Judge Elrod asked you about particular cases, two particular cases, but we've got a handful of cases of fairly recent vintage, construing, acting under, and so on and so forth. So if not a specific case, what's your argument against those cases? Because that's what you're up against, our precedent. We had Latchley, which was fairly recent, laying all this out. So unlike some cases we get where there's just not much law out there, this happens to be one where the court has a lot out. So we got you in terms of your overarching statement of why it ought to be something else. But for now, concentrate on telling us how, in this precedent, how you prevail in the face of what acting under has been construed, in that light. Do you follow my question?
Yeah, I follow your question.
All right.
Mr. Box is claiming that he was the instrument by which we obtained the money from the federal government, right? He says it started with him, it progressed through him, and it ended with him. That's what he is claiming in his lawsuit, right? When we're getting the money from the federal government, we are acting under the federal government's control. And one of the things that they required us to do was to only use people that were licensed brokers, right? The people that they wanted to have involved in this process have to comply with federal law. That is where it's distinct, right? We are acting under the federal government's control in a project that they've decided whether or not they're going to fund it or not, and the terms and who's involved. And Box is claiming he's right in the middle of it.
Well, did he obtain money and give it to you?
He didn't have any actual involvement in this project, right?
Did he ever obtain any money and give it to you, which is what his oral contract he's claiming?
Our view is that he contributed nothing. The only thing, he attended one meeting as a potential investor, an equity investor in the project, when OPEC people were present. That was his only involvement from our point of view. But he's claiming that he was involved in the whole thing, that he somehow submitted documents to them. And, it's the problem with this case is that the petition is his allegations are so far from the facts. But if he did do the things he's claiming, he's right in the middle of the things that the federal government was telling us to do, and how to do them, and who should be involved in it. And that is acting under a federal officer. Anytime, a private party is engaging with the federal government, they're almost always doing it voluntarily, right? It's not like the people acting under a federal officer are there because they're compelled. So the district court's argument that the fact that we stand to benefit from this doesn't seem to be a factor that would be relevant. The electric cooperatives benefit from it. The various healthcare entities that administer things benefit from that relationship. They're getting paid from it. So the fact that we stand to benefit as well as the federal government shouldn't be the factor that prevents us from being able to act under a federal officer. And the district court said that there's no indication that DSC would have performed these things in our absence. Well, if DFC wanted to fund this project or any other, it would need a placement agent. It needs a bank to sort of manage the money, both coming in and going out. Right now we repay the investors on behalf of DFC. Well, if DFC would have to manage that on their own, the functions that we are performing in this transaction and in this financial relationship would have to be performed by somebody, and if it's not going to be done by the entity in the relationship with DFC, it's going to have to be done by DFC. So I think that we are analogous to entities that have sort of been deputized or acting on behalf of the federal government in connection with whatever goal the federal government is trying to achieve. In the response brief, there was an argument made that the standard review is de novo for legal issues, but factual findings are subject to clear error analysis. There was no evidence submitted at the trial court other than my client's declaration. I don't believe the district court made any factual findings for which there to be a conflict of evidence, but the evidence that was before the court establishes the acting under relationship, and I believe that the district court erred in remanding it.
All right, thank you, Mr. Ternan. You have preserved your rebuttal time. Ms. Long.
May it please the court. My name is Heather Lynn Long, and I represent the appellee in this case, Mr. Douglas D. Box. The district court got it right in this case. This is a state law case about state law claims. In my time before the court, I'm going to focus on the federal officer removal jurisdiction, and if time permits, I'll address any questions about the federal question issue. Here, federal jurisdiction does not exist for two reasons. One, the appellants were not acting under a federal officer at the time they entered the agreement with Box, or at the time they refused to pay Box. And second, the well-pleaded complaint rule applies, and the injection of a federal question is impermissible in this situation. Now, turning to the first point, the district court found that appellants didn't satisfy the acting under element under the federal officer removal statute, and it was right. This court need look no further than its recent decision in Mitchell v. Advanced HCS that was issued just weeks ago. There you had a nursing home who was claiming under the PREP Act that their status as a designated critical infrastructure created a relationship that required them to respond in the way that the government was dictating under COVID and under close governmental instruction. And the court rejected that argument, and it pointed out and reminded litigants that while the words acting under are broad, they are not limitless. There is a requirement that the private party has a subordinate relationship with the federal superior, simply complying with law, no matter how highly detailed the regulations are, how highly monitored or how highly supervised, is not enough unless there's that aspect of direction.
What do you believe is our most analogous case?
I would say your most analogous case is Mitchell, and then following Mitchell, Watson is also very analogous because it, as Mitchell shows, was kind of began and forms that root of how Mitchell came to the conclusion it reached. And because both cases, and there you're dealing with Philip Morris selling cigarettes, and Watson, say that the statutory purpose and history behind the federal officer removal statute is to prevent interference through civil litigation or criminal litigation in the state courts with the government's operations. And that regulation, again, supervision, monitoring, is not always acting under. And when we look at Mitchell, it's a very similar situation. You have a private entity who is, because of what they do, falls into a category of a particular designation, and that because of that, there are certain regulations. We see this also in the airline context. You have airlines regulations that are very extensive that apply to them, and a private actor who is following or attempting to comply with those requirements. But as we can see in some of the district court cases that like for instance, K versus Southwest Airlines out of the Northern District in 2005, that kind of requiring in the airline context, which is so involved in regulation, was simply not acting under, didn't rise to the level. And to go to Judge Elrod, your point originally is this is very different than the cases we see like, and I hope I don't mess or make a mess of this name, Lediole, excuse me. I believe that's how it's pronounced.
I think it's Lachole.
Pardon?
I think it's Lachole.
Lachole? I have done a ton of trying to figure that out, and I'm glad to know. And
It's like down here, Burgund. Well, it would be Burgundy, but down here it's Burgundy. So, you know, you get these different pronunciations that are a little nuanced.
And I will tell you, for my hearing impaired self that doesn't think in sounds, they're particularly difficult to sort out unless I've heard them a lot. And that aspect, though, turning back to the point that the court led with in the earlier argument, is that this is not like the cases involving asbestos in Avondale, or whatever it was calling itself at the time in its various iterations, was a federal contractor hired by the government to either rehabilitate ships, strip them down, or build them. And the government in those situations, if you look at the specs, they spec out, these are the Cranco valves you need. You're going to need to have these, this type of insulation, because that's where they're getting it from, one. And they also spec out what, when you're removing or breaking down a ship, what's being removed. That's not what we have here. The government in those cases needs a ship, no matter what. They're either going to have employees or personnel do the work or hire someone. And that's the difference here. The government here didn't approach PetroTel. PetroTel.
Counsel, opposing counsel says your client wasn't involved at all in this deal, and that if they had been involved in the deal, that it would have been illegal, basically. Are those arguments that can be made in state court?
Yes, those can be made in state court. First, the question of their absolute denial of Mr. Box's involvement, despite, as you can see in our petition that was removed, is very specific and very detailed, identifying specific events and circumstances that occur. It's not global, it's not generalization. And to go to the second part of your question, or I should back up, that is a fact issue, this contention that, and they have boldly and aggressively stated he's lying, right? Box is not a liar, but regardless, I will not engage in that tone and respond to that nature of aggression in the arguments below. But going to the second point, or second part of your question, the defense of federal securities and saying it's a violation both is an issue of illegality or an affirmative defense. Box does not have to prove he was not a broker-dealer. They may allege that the contract is void, and that's their burden. And so that can be considered by the court, and there, as is addressed in a lot of cases touching on federal question. Again, it's not a substantial issue as well, but also factually, The period of time we're talking about that is the underlying basis of events for Box's claims does not extend, into this process of funding. So what the PetroTel appellants have broken down, and you can see this in the two arguments that they made in supporting federal officer removal. First, they started with, in the notice of removal, hey, the DFC actually tasked us to go do this project in Oman. But that wasn't the case factually, because the Oman project, as the district court pointed out, had been in PetroTel was working on it for nearly a decade before the DFC and OPEC became involved in the first place. But second, they've broken this down into the process of doing the application to obtain an award. And then second, when they switched theories in the response to remand, they then focused and said, no, the reason we're acting under, and this conduct is connected to federal officer direction, is that there is so much regulation and control over how the funding, the disbursement, and the repayment of the loan is done. But if you look at the facts we've pled, we plead that, one, the contracted issue was entered long before OPEC and DFC got involved. It was also, that's when the misrepresentations occurred, that's when the fraudulent inducement occurred that we allege. But two, that the breach occurred after the award was granted, but not during the funding process. There's no point in which Box is demanding or alleging that PetroTel has to pay Box out of any federal funding that PetroTel received, because PetroTel is a private company that exists and there are more aspects to its business. Now,
if PetroTel could go to DFC for funding, for financing, why would they need your client?
well, PetroTel, as you can see in Chopra's affidavit, actually had years before tried to approach OPEC, and it had stalled out. The OPEC application process in obtaining those benefits and that financial support is a very involved and selective process as far as determining whether something meets the agenda. However, what happened and how Mr. Box became an essential part of this series of events and ultimate accomplishment was originally they approached Box and said, we are looking for assistance in coming up with funding. They didn't say where from. And Box actually, as you can see in our petition at, I believe, page 30 or 28 of our petition, originally approached this with contacting his contacts. Mr. Box is the son of one of the founding oil tycoons who was in the 50s and 60s. And so his family was very connected in that industry in the area in North Texas. So that approach, because again, they approached Box. Ravji, their attorney, PetroTel's attorney, came to Box and said, I want to talk to you about an opportunity. It came out of the blue. They were professional acquaintances, not good friends. Hey, I've got an investment opportunity. And it was there that Ravji said, hey, I've got a client that needs help getting funding. You have some connections. And then the ultimate dinner where the oral contract was entered occurred and discussions were furthered. There is a dispute between the parties. Box says, I never, ever was approaching this or indicating that I was a potential investor. And PetroTel denies that. That's a factual issue for decision another time. But the aspect that, the aspect of what his involvement was that by just sheer a moment, right place, right time, he connected with the then newly appointed head of OPIC, Mr. Ray Washburn, at an alumni event. And Mr. Washburn recognized Mr. Box because Mr. Box is an author, and Washburn had familiarity with one of Box's books. And so they got to chatting, and then later Mr. Box was having a conversation with his brother, and he mentioned, hey, what about looking to OPIC? Because the prior efforts to find individual or corporate investors had not become fruitful. And so Box called Mr. Washburn and said, could I come and sit down with you? And it was during that meeting that Mr. Washburn explained, look, here's kind of the process, especially with a country like Oman. Oman is too wealthy to actually fall under the underdeveloped country aspect of the mission of the DFC or OPEC. And so to obtain funding, Mr. Washburn explained that there has to be a request for an exception submitted to say how, even though the wealth of this country is higher, that there are underdeveloped aspects, and that it would further the process of creating and establishing better economies abroad. Now, Mr. Box was able to take that information and say, hey, this is the process, and have that connection. And he assisted PetroTel throughout that first aspect of the process. He was the one that PetroTel said, Doug needs to send this exception letter on an email to the individual at OPIC that was supposed to receive it. And so he was involved, but he was not involved in this funding process with certificates of participation or obtaining funding and using what PetroTel tries to claim or infer as the federal officer, a placement agent. Mr. Box wasn't involved in that, and his involvement doesn't reach the securities question. At the end of the day, it was PetroTel who went to the government here. The government didn't come to PetroTel and say, we need something. PetroTel was approaching the government for PetroTel's benefit, not the government. That's how the involvement came about, and that's the paradigm under which the interactions between PetroTel and the government played out. And again, turning to this aspect and distinction of this case as opposed to the cases involving federal government contractors, the courts frequently distinguish between private companies or private persons and government contractors. And they have routinely rejected the corporation's efforts to equate acting under and the requirement, equate those private companies, with the acting under requirement. We see that in Watson versus Philip Morris. You have the highly regulated tobacco and cigarette sales industry, but the court said that's not a federal contractor helping the government do a task that the government's got to accomplish one way or the other. Russo versus Mount Vernon Neighborhood Health Center out of the Second Circuit in 2014 is illustrative and persuasive though not binding. And there you had a health center that received federal grants and was subject to federal regulations regarding the services that it provided, but it was not acting under the federal statute because it wasn't doing something that the government wasn't going to provide those health services in that context, that were issued in that context by itself or having to hire someone. It was regulating the industry. And again, we see that in K, which is the case involving the airline Southwest out of the Northern District in 2005, and Jackson versus American Bureau of Shipping, a 2020 case out of the Southern District, where private classification of those responsible for inspecting the ships for seaworthiness under federal standards did not reach federal jurisdiction merely because the Coast Guard imposed restrictions. And for these reasons, we ask this court to affirm this state court case that is over state court claims. Thank you.
Thank you, Mr. Lynn. Back to you for rebuttal, Mr. Ternan.
I want to make 2 points. The first general point, cases like Mitchell, which dealt with the COVID-19 scenario and this sort of general guidelines or rules or designations of what people should do, those are not acting under a federal officer, and that's what the courts have said. This is a specific project. Yes, we had ideas about how the project would proceed before we approached the federal government. The federal government has foreign policy objectives it wanted to achieve, and we had to modify our project to fit into what the federal government wanted, and that's the project that there is today. It's a particularized event. There's not some general regulation, some general benefits, some general rules that we're acting under. We're acting under the federal government's particular guidance on a particular situation that they've decided they want to achieve something, and we want to achieve something, and they're going to work together to do it. So that's how Mitchell and Watson and these other cases are different, right? There's an actual federal officer that tells us what to do and has made decisions on what to happen. There's a board of federal officers that decide every step of the process whether to go forward. And then there's the argument, the second point, there's this argument made by Box that, he wasn't involved in the process of getting funding. Well, that's because he did such a minor role of like sending an email or he has a meeting with somebody that he doesn't understand what the process of funding entailed. He didn't understand what was going on before he got involved. He doesn't understand what happened during his involvement other than the few things he saw or what happened after. And yes, there was a change of administrations in 2017. The foreign policy goals in the Middle East changed. Congress changed the statutory regime in 2018. The Overseas Private Investment Corporation went away and it became DFC. All of those things mattered a lot more than what Box's involvement was. But he's claiming in his petition that the journey to that award started, progressed, and ended with Box. That is what his claim is. He's claiming he's owed $2 million for helping us get a $300 million loan from the federal government. That's his claim. We, during that entire process, were acting under the direction of a federal officer. We contend that he's not owed a dime because A, there was never an agreement, but B, if there was an agreement, it would be illegal under federal law. A federal court should decide if we're right or wrong. That is what Congress decided when it created federal officer removal. If you're doing something, you're acting under a federal officer, you've got a federal defense, you should be in federal court. And attempting to plead this as a state law case, which is what Box tries to do, doesn't change that. You look at the evidence, and the evidence in this case was presented by my client, not by Mr. Box. You don't take Mr. Box's allegations as true. He's never sworn to any of these things as true, and they're not true. What happened here was that my client had a project overseas, sought funding from the federal government. Federal government gave some directions on how it wanted that project to go and what it needed to be in order to get money. Told us to go out there and make the deal happen. We helped them find people that would work on their behalf. They could say yes, they could say no. Sometimes they said yes, sometimes they said no. We raised money in the government's name. They could have said no at any time. They can still say no. There are going to be drawdowns in the future. We are acting under the federal government, a federal officer. This court has eliminated the causal nexus requirement. It's recognized that in 2011 that Congress brought in federal officer removal. And the acts at issue in this case by my client are associated and connected with activities conducted while under the direction of a federal officer. And therefore, I believe the district court erred in remanding this case, and this court should vacate the remand order and let this case proceed in federal court. Thank you.
All right, thank you, sir. Thank you, both counsel, for your briefing and oral argument. The case will be submitted. We will call up the third case for the morning, 2-1.